This time then, if the attorneys in 126642 Freestate Electric Cooperative versus Kansas Department of Revenue Division of Property would like to move forward.
May it please the court, Ted Smith for the appellant. Property Valuation Division be referenced as PVD through arguments for the Kansas Department of Revenue. Thank you for this opportunity to present. And again, I'd like to reserve 3 minutes of rebuttal time. Primarily, this case revolves around evaluation of a series of nonprofit rural electric cooperatives and the valuation approaches and methodologies prescribed by the Property Valuation Division through its director, David Harper, as it extends down to the actual performance of the valuation by the PVD and basically determination of unit value for each one of these 8 nonprofit rural electives. Now, this is sort of different than your normal valuation case because when we deal with utilities, it is not the county assessor or appraiser who's coming in and supporting their validation. PVD is basically setting the methodology, setting prescriptions under USPAP and its own best judgment for the best valuation policy in the state. That's being communicated down to PVD staff who then perform the valuation. So they're doing both.
I ask you about that.
Yes, sir.
Has to do with the burden of proof and issue of what I would call jurisdiction, just exactly what did BOTA decide? Here's my question. In a valuation case, statute provides that county appraiser or the appraiser has the initial burden to come forward with the with why it did what it did, and to set that up. And that's the way it normally happens at BOTA, and then it would go up. Well, we've got this de novo review at the district court, right? Seems like there's a real lack of alignment between statutory schemes that we've been used to, this, de novo animal that we've got. My question is, once it gets to the district court and it's de novo, shouldn't the division have had that same initial burden come forward with its valuation methodology and then let the taxpayer respond to it, as opposed to the way the APA, the Administrative Procedure Act, comes right out of the chute and says the petitioner has the burden of proof. You see what I'm saying?
I do.
And
Justice Pyle.
so shouldn't that have been the way it worked at the district court? That's one question. Second question is looking at BOTA. The fact that BOTA didn't go through the analytical process that it always goes through evaluation case tell us that BOTA didn't think, at least, that it had that valuation question for it.
Let's begin.
That all makes sense?
I think.
Okay.
And I'll try to answer your question, starting with the first one. This is something the parties struggled with during the course through BOTA and through the district court review. And Department of Revenue basically maintains that the burden rested on the taxpayer in this case with regard to providing evidence in support of the fair market value of valuation.
At what level?
Both at the BOTA level and also at the district court review de novo. That being said, in the last 5 or 6 years, there's been a lot of movement legislatively to shift that burden in many property tax cases, residential, some commercial. The legislature has not addressed this issue of utility valuations. So we've maintained that the burden still continues to reside on the taxpayer in these circumstances.
Your position would be that at Boda, you did not have that same initial burden that county appraisers and appraisers have typically in a Boda case, in oil and gas and other kinds of valuation cases.
Well, I would say this case is a little bit different in the sense that part of our argument is that there's two different legal defenses or arguments being made. We have issues of uniform and equal, and we have issues of fair market value and valuation. And I believe those issues are separate. Now, I understand that fair market value oftentimes is a component of establishing uniform and equal, but there are also circumstances where they're at odds. This court and the United States Supreme Court have been clear that when there is any kind of tension between those two concepts, that uniform and equal is basically controlling. Now, in this case, PVD provided a use PAT valuation that was provided to the taxpayer. It concerned an evaluation of comparable sales, cost approach, income approach. It basically factored to put a lot of emphasis on the income approach. And that was submitted to the taxpayer and also was an issue that was presented to Boda. That is the only use PAT valuation that was before Boda on this issue. Now, the taxpayer basically in its appeal to the Board of Tax Appeals primarily stated this is an issue of uniform and equal. Department of Revenue PVD provided its use PAT valuation to basically support its estimate of value. The taxpayers presented argument from an independent individual, expert witness, who basically had previously been a tax rep for these recs. And as a tax rep for these recs, he had basically formed this opinion regarding how to treat net operating income. In his report to Boda and in his report to the district court, he was very clear to say, I'm offering this opinion regarding issues of uniform and equal. And testimony, it was clear that this was not an estimate of value. This was not a use PAT valuation. So at this point, Board of Tax Appeals and the district court, the only use PAT valuation they have for fair market value is from the PVD. Now, there is testimony, 2 expert witnesses from the Department of Revenue and one, Mr. Barbrich with the recs. They offer opinions as to uniform and equal as applied.
I have a couple of other housekeeping things, so bear with me for a second. District court opinion talks about there being 18 rural electric cooperatives, but I kept reading 16 in all the other documents. Surely we know the difference.
Yeah, my understanding is that there are 10 actually there's 18 altogether, and that the 8 are parties in this litigation.
So the district court is right. There's 18, 10 in and 10 out. Okay. Another housekeeping question is you just added to the record on appeal, the rural electric cooperatives expert report that was given to the district court. Okay. There's a reference from the rural electric cooperatives that report is virtually identical to the report that was given to Boda. Do you agree with that?
I do, Your Honor.
Third question, then I'll shut up. And this is going to sound facetious, maybe. But in looking at the order of the district court, the remedy that it's ordering, which is to give appropriate consideration to the adjustments to the current methodology, can't figure out what that means. Are you really and I guess it gets down to, are you really an aggrieved party? Do you really think that there's something that you're being forced to do other than give appropriate consideration, which would be to look at this report and say it doesn't have anything to do with the uniform appraisal procedures that the statute requires, and you're done? I just being too cute by half or, I mean, so I guess the answer is, how are you an aggrieved party from the district court's
Oh,
order?
Justice Miles, we are very aggrieved in the sense, and I have 2 minutes and 30 seconds left, Your Honor. So I would ask for maybe a little bit of leniency as far as making some other arguments. But the fact is the big part of the district court's decision is it basically said the methodology employed by PVD or the director of evaluation can be fine-tuned. It can be better adjusted to reflect accurate value, fair market value. And I believe that that is well beyond the standard for unreasonableness, which is 621C8. And fine tuning is very much different than saying is this methodology employed by PVD so wide of the mark that it's unreasonable or implausible. Thing is the district court is basically saying, and we know to the dollar how this adjusts the valuation under the income approach if we are to consider a reduction in income by this accounting concept created by the recs. So I believe it's a final order, and I think we've been aggrieved in the sense that, number one, PVD's methodology, its discretion as an agency, its expertise that's been granted to it by the legislature in this special capacity to set methodology has basically been co-opted by the district court, and it's effectively acting as a policymaker. Not to say that it's been unreasonable, but to say you need to fine tune your processes. And effectively the court, and more importantly, even if we go back and consider it in the context of this one case, 2019, 2020, we have many years of appeals that are pending afterwards, right? And the concern is that if PVD is forced to make this adjustment to its methodology or its agency expertise on this arbitrary classification or subtraction from income, my concern is that the income approach no longer becomes really a valid mechanism for valuation with regard to this industry. Because in the context here, they're basically saying that an MSA adjustment, which has nothing to do with the relationship between the customer and the rural electric cooperative, it doesn't reflect what is the cost of it, the expense, the operating expenses of the RECs, because they never pay it to the wholesale distributor of electricity. When they deal with their customer, a customer that has to use this service because of their physical location, they send a monthly invoice to the customer and they say, this is what you pay for electricity. Now, the RECs don't make it clear in that monthly invoice that guess what? A portion of this is going to your equity interest. Congratulations, you're buying shares or more equity interest in a company like Evergy. No. In the invoices received by the customers, it's basically saying use this much electricity and you're going to pay this much. Now, do these people?
Can I just jump in here? Your discussion of the invoices is a helpful bridge to my question, I guess, which is, I understand this goes beyond the technical legal questions presented, but I am trying to wrap my head around the motivations or incentives that lie behind the economic decision-making of the parties here. What is, in your view, the impact on the incentives of the RECs if you were to prevail? And then I guess the flip side, what is the impact on the incentives if the RECs prevail?
Well, Justice Stiegel, I can't really speak for the initiative, I mean, the interests of the RECs, right? But what I do want to say is that these are internal accounting business decisions. And when I'm conducting evaluation to the income approach, I'm looking at operating expenses, day-to-day expenses, not the below the line treatment or accounting classifications within that specific.
And I understand that, but I guess I'll just, maybe you don't want to answer the question.
No, please.
But I'll ask it again. Like, just in a global sense, surely you have an understanding of how these market players react to different legal rules in their economic decision-making. We need to make a rule here. I'm trying to discern what impact that rule will have on the incentives of the different players.
Sure. If you rule in favor of PVD and reverse the district court, what that's going to tell the Rex is that this conceptual concept of non-value creating income is not a mechanism for relief or lower property taxes.
So would I be correct to say then that it creates an incentive to pass the credit on to the ultimate consumer, which reduces the equity held by the utility? Is
Right.
that the incentive that that rule would create?
I believe so. It would basically return or lower the costs in that year, in that month for the cost of electricity.
Okay.
That would have a effect of reducing the price, or it would be another incentive. There's other
And
issues.
it's a trade-off, right? It's a trade-off between returning the capital to the consumer versus retaining capital in the, call it a rainy day fund, call it whatever you want, but retaining the capital in the utility, which then would become taxed.
Justice Stiegel, I think that question gets to the heart of this case in a sense that I don't believe that's an immediately, just because their bylaws say that it's to be treated as margin or profit upon its receipt. The REC doesn't know what its margin or profit is when it receives that payment for the customer. Even the REC's own witness, Mr. Wellwig, said, yes, these capital distributions, capital allocations, these capital dividends, they're income once upon a time.
So because this is a public utility, it strikes me that some measure of sort of policy of common good is in play here. Was there any testimony or any suggestion in any of the proceedings below that this incentive would destabilize the financial stability of the RECs?
I do not remember there being.
And not because they're having to pay a tax, but because they're being incentivized to pass through the credit.
No, I don't believe it's a credit. I don't
Well,
believe
okay,
it's
I
a
may have,
credit end of the year when there's a.
maybe
profit
that was the
overall.
wrong word, but I think you understand my question.
Right. I mean, the thing is I just want, and basically setting up net operating income, I want a reasonable way of determining what revenue is. And this accounting, this is a process where it is more form than substance. And effectively, I want this court to consider the essence of this transaction and that the customer who is forced to be a consumer of electricity from these companies is basically paying for its use of electricity. Now, to say that it now has an equity interest and somehow that should reduce income, well, in my brief, I make it very clear that that money may never come. Well, there's no interest basically retained by this customer if the company, the REC, uses it for 19 or 20 years.
There could be an argument made that the interest retained by the customer is a financially stable utility that will not run the risk of essentially being unable to provide services. Was that argument ever made?
I think I'll let Mr. Musil obviously speak to that issue in more detail. I don't think there's any evidence that any of these RECs, 18 going out of business, or that this issue will basically destabilize them as being able.
That was
to
my
provide
question.
services.
Thank you.
And let me, oh, go ahead. I don't want to interrupt your final comments on his questions. I'll let you wrap up and I have a couple questions.
I think a big part of this MSA treatment, as far as for the RECs are concerned, has to do with their ability to secure lower interest on some government subsidized loans. And that's a big part of why they classify it the way they do. I just don't think that's an above the line conceptual item that should affect net operating income.
Okay, my question is on the statute that creates these procedures for appeal, 74-24-26. The trial de novo, which will include an evidentiary hearing at which issues of law and fact shall be determined anew. Tell me how we interpret that statute in a way that still has preservation as a relevant question between the BOTA appeal to a district court proceeding. In other words, do we still have those same prudential issues despite this trial a new sort of concept? And explain how that works in terms of a statutory construction.
So that's the struggle, Justice Wall, is the concept of you've, like in the matter of Walmart, right? You've basically said, hey, a lot of issues regarding valuation should be considered by the Board of Tax Appeals. Those are fact issues, or we shouldn't get into how you should do something specifically. But this case is in a sense where the court not only basically said fair market value needs to be reconsidered or fine-tuned, it basically said the overall methodology employed by PVD, effectively sort of like its guide, needs to be reevaluated in light of the court's opinion. And, you know, the issue is that may address it with regard to 2019 and 2020, but, you know, there's obviously a lot of litigation on the other side. And the thing is how this court rules will also have an effect on those other 10 recs, right? Because if they see that this court has basically recognized this margin stabilization, this wholesale distributor accounting classification, that's not really associated with revenue or net operating expenses of the rural electric cooperatives, they're going to do that too. I would, if I was their attorney, I'd recommend it to them. And the fact is that's going to have an overall effect of reducing, and that's going to basically, if they're effectively saying that the profit or margin is defined by the co-op according to their bylaws and that should be reduced, that's an internal business decision, affects or can be reduced from revenue.
I understand the substantive argument. I guess my question was more, I took it to read that you took issue with the fact that was even in play at the district court level. And I assumed it was because of the statute, despite being de novo review, still didn't mean you can just, you know, tee it up all anew without having BOTA have the first bite at the apple, so to speak.
The thing is that gets us to 621C, right? And the four issues raised by the district court as far as review. I believe a district, again, getting back to this concept of in the matter of Walmart, the thing is you have the specialized Board of Tax Appeals with an appraiser, an accountant, and an attorney. It's like a joke, right? Start of a joke, a punchline. But the thing is, and then you have to move the district court, right? Now, fortunately, in this case, we had a pretty sophisticated judge who understood property tax laws. But all of a sudden, we move to de novo district court review. And with regard to the issues raised, it's de novo, right? New evidence can be presented, new legal arguments can be made, but that's limited to the arguments that were raised at BOTA and ruled on. And in this case, I argue the recs in this case basically made this a case about uniform and equal. And their expert opinion report at BOTA was not a valuation. It was not a USPAT valuation. So BOTA basically sees in front of it one USPAT valuation and rules accordingly. And I don't believe they can come back and now argue fair market value at the district court because I don't think it was sufficiently argued below.
Justice Wall talked about that being a preservation. To me, it's a jurisdictional issue. Because you have to exhaust administrative remedies before you get into the judicial system. So you can't raise new issues that weren't raised before BOTA. Does that make sense?
Yes,
Okay.
Justice Biles.
The district court has a couple of references about that timing doesn't matter in the context of, you know, when the member gets this capital account, and whether it's something, it's real money or not to them. It says timing doesn't matter. But the whole notion of valuation of property is a snapshot on a particular day for the year. And so then every year changes. So was the district court sort of ignoring that whole concept of valuation by saying timing doesn't matter when we're talking about these, you know, patronage accounts?
I believe so, Justice Biles. I think that's a big part of this. The fact is that there's a conceptual aspect to the income approach, right? With comparable sales, you have actual numbers of comparable properties. With the cost approach, you basically develop a real world inventory. You're going to use the income approach, you have to basically invest in its conceptual nature. and follow those rules. And I understand that some of those things might result in some variance, right, in overall valuation. Like in this case, some of the recs had their valuations go up. You know, did their real personal or tangible property, did it all get replaced and become suddenly more valuable? Simple argument could say no, but the thing is that is the concept. If you're going to basically rely upon the income approach, which was the lowest valuation indicator determined in the USPAP valuation, we did a cost approach that was much higher. But if you're going to commit to this conceptual approach of the income approach, you have to follow its rules. And those are rules that the recs understood both before 2019. They understood how PVD would basically consider income, that we would basically look to the substance rather than to the form. And they still made those decisions. They must have did them for other reasons. But hopefully I answer your question, Justice Biles. I've used up my time. Is there any more questions? Thank you.
Greg Musil representing the appellees here, including Freestate Electric Cooperative Incorporated. May it please the court, Mr. Smith. You're interested in rural electric cooperative taxation early on a Friday morning. The question here is, did Judge Watson at the district court level, after hearing 3 days of testimony, more than a dozen witnesses and dozens of exhibits, have substantial evidence in that record to determine that PVD had not applied 79-5A04D properly, which requires PVD by its choice to value these RECs based on utility operating income capitalized in such a manner and at such a rate as to be just and reasonable.
Let me
That-
stop you there.
Yes, sir.
On your state law violation claim, I want to make sure we agree that just because you asked for de novo review at the district court level does not let the taxpayer add issues that were not considered by BODA. Do we agree on that or not?
I agree on that, and I'd be happy to speak to how valuation
That's fine.
was raised.
And that would be jurisdictional as opposed to some sort of prudential preservation.
That's correct, Your Honor.
Okay, I just want to make sure we agree with that.
Let me forget my outline and speak to some of the things that you raised that you're interested in. The first thing on valuation, when a property taxpayer files an appeal, whether it's to PVD or the county appraiser, first of all, understand it is most likely a layperson. It is not going to be a lawyer. And I don't think we should require pigeonhole pleading, which is what PVD has said. You didn't specifically mention, I am opposed to the valuation of this property, even though valuation and NOI, net operating income, is mentioned in the first filing to PVD. When we get to the Board of Tax Appeals, my opening statement, I mentioned 3 times, and I can give you the record sites if you want, about how our expert is going to speak to valuation, how our witnesses are going to speak to valuation. Don Helwig, who testified on behalf of the RECs, spoke to valuation and how this adjustment affects individual valuation. Angie Dick Erickson, who's the CEO of Twin Valley, spoke to that. Now, if you look, and I looked last night, if you look at the record, valuation, values, valued, values are mentioned 244 times in the BODA record. Now, some of those could be with respect to the uniform and equal portion, I admit, but 244 times in the Board of Tax Appeals record, the word or subject of valuation occurs.
But nowhere in the BODA transcript that we have in the record. Well, actually in any of these, either one, does anybody mention whether this income approach methodology that's being used violates generally accepted appraisal procedures? That's the statutory standard. So to say that the statute's been violated seems to me that somebody somewhere has got to say, we've looked at this income approach being used by the division and this ain't it. And no one said that.
I believe, no, I don't agree, Your Honor. I think
Okay.
if you fairly read Mr. Barbarich's testimony and his report, which I will note was admitted by stipulation and without objection at both BOTA and the district court. He speaks to the fact that when you do this adjustment the way PVD does it, he's speaking to generally accepted appraisal practices.
He never
He's-
mentions the standard. He never mentions that phrase in either the report or in his testimony to BOTA.
I
I've
will.
read both.
I believe you, Your Honor. I don't think you can fairly read the context of his report and testimony without indicating as a person registered by the American Institute of Certified Public Accountants, which is his standard, along with some other qualifications that are in his CV, that anything other than that makes sense for why he's testifying.
And when the district court put in its order that it was allowing these extra, I'm just going to call them extra issues, so we know what we're talking about, the state law claims. It quoted one statement, one sentence from the BOTA order, right?
Correct.
What the district court didn't take into consideration was on the first page of the BOTA order, BOTA says what the issue is, and it's uniform and equal. And it doesn't have anything to say about the state law standards. So it just seems like the one sentence that's being seized on by the district court to open up these other issues is contrary to what BOTA said on the first page of its order was the issue in front of it being raised by the RECs. It's hard to reconcile that.
In that first paragraph or the first page of the order from BOTA, BOTA says that basically that the RECs believed their valuation was, quote, artificially inflated, unquote, by PVD's development of the MSA. And then at the end, it said, you've not presented sufficient evidence to persuade us, quote, that the instant RECs were not appraised at their respective fair market value.
But you're leaving out the part of the BOTA sentence about the issue that says it results in non-uniform and unequal valuations of RECs statewide. That's the constitutional question that was raised, particularly when you look at the notice of appeal that went to BOTA from the cooperatives that also said our issue is the constitutional issue. It seems to me that that lines up much better than seizing on this one sentence at the end that the district court seized on. Because honestly, you know, we've seen lots of BOTA fair market value orders. And the one you've got isn't it. That's not the way they do fair market valuation. So again, trying to figure out whether the district court exceeded its jurisdiction by adding issues that weren't decided by BOTA, weren't part of the BOTA order, is really difficult to line up.
I think maybe this gets into, I think it's the Hansen case that talks about issues not decided by the administrative body. Because I agree with you, BOTA generally will have a section on, most of their cases are about fair market value, and they don't do uniform and equal. They did not here. And frankly, it would have taken them a lot of time and effort to do that. And they simply, I believe, took the one sentence and said, you didn't present enough. I don't know that we could have done any more because we presented everything the same at BOTA that we did at the district court. Same exhibits, as Mr. Smith admitted, it was the same expert witness report from Mr. Barbarich. If we were not specific enough, then that is my fault. But the evidence presented there gave ideas of valuation on each and every REC. And that's what BOTA had in front of it and chose basically to dispose of in a one sentence.
Let me ask one other question that's been bugging me, and then I'll leave you alone. I can't figure out how 77-621, which sets out the ways you can have judicial review of an agency order. I can't figure out how that aligns with the OVO process, because as I grew up practicing administrative law, 77-621 was there to limit the scope of what the district court could look at. But here, we've got this new evidence, you can come in, maybe not new issues, we've agreed, but new evidence can come in, you can make your case de novo. That doesn't seem to be compatible with 77-621's limitations on what should be talked about by the district court in doing agent. Have you given that thought?
I have, and I think this court has, because you decided the Bicknell case, where you had a similar issue on a Kansas Department of Revenue issue on domicile. And you had a regulation and you had a district court decision that you then reviewed.
And Bicknell doesn't ever mention 77-621 in those
Right.
items.
But
And that's what Bicknell's the one that's the only case we've got. That's the one that I read it again last night. It sort of just puts the district court in Boda's shoes unless the parties relitigate the facts. And that's not a 77-621 analysis is my point.
But we know why 74-24-26 C4B was passed. It was a legislative effort to make sure that taxpayers had a direct route de novo to the district court. I don't think there's any dispute about that. And then Bicknell follows that and says, okay, you get a de novo, new facts, new findings of law. If you combine that with the Hansen case, which was cited by PVD, but only part of it was cited. It was cited about how you have to give some deference, quote unquote. The next sentence says, we must be careful in granting that deference. Otherwise, we will undermine the ability of courts to perform judicial review. And I agree there's a tension between those, Justice Biles, but I think when you combine the adoption of 24-26 C4B and the notion that we are not going to give the same deference in situations where the agency hasn't prevailed in providing substantial evidence to support itself, or substantial evidence has been demonstrated by the challenger. And on the burden of proof, I may do it anyway, but I didn't want to make new law, so I didn't make the argument that PVD had the burden going forward. We accepted the burden.
It's just that initial burden. I mean,
Right.
the
But-
taxpayer usually carries the bigger burden.
Right. So we took on the burden at Boda and we took on the burden at the district court, and we believe we carried it in both places.
I want to clarify to make sure I understand your argument on that earlier issue about, and your exchange with Justice Biles about the new issue. It seems to me like there are maybe about 3 ways this could be looked at. I think they're probably overlapping, but one would be that fair market value is always the issue, that valuation. Second would be that the uniformity fair market value is inherent or intrinsic in the concept of uniformity. And the third is, no, we very specifically made clear we were challenging fair market value. Which of those are we looking at all 3 of those? Is it one?
I believe it was clear to both tribunals, Boda and the district court, that valuation was a direct issue. But at a minimum, you cannot talk about fair and uniform without raising the valuation issues and arguing and presenting evidence that the valuations were wrong. And that's what we did. So if we didn't make it explicit enough, I think it is clearly implicit in the record at Boda and the record at the I guess the record of Boda is what matters, so you can bring it up to the district court. And
Is it fair to say that your argument was, look, because your valuations are wrong, you are creating a uniform and equal problem? In other words, if you fixed your valuation, we would have no uniform and equal problem because all the RECs would be treated the same. The only reason they're being treated differently is because they handle the so-called credit differently. Am I understanding that correctly?
that is exactly right. If our position had prevailed, it would apply to all the RECs.
So
and the ones that
your
have passed-
argument, sorry to interrupt, but your argument is that the valuation question was completely subsumed within the constitutional argument.
I don't think that's right. I don't think that, I mean, the value,
Well, there's no way you could prevail on your constitutional argument unless you proved the valuation method was wrong, or the valuation being done by the state was wrong, right?
that is correct, but we could have prevailed on the valuation issue and still lost on the uniform and equal issue.
Sure,
That's
but
a
the opposite
distinct
is not true.
I think that's correct.
You can violate uniform and equal and still come up with fair market value, right?
That's correct.
I mean, your process can still result in fair market value.
Right. And we could have prevailed on our values with some other, based on the evidence, without the court or BOTA finding that it violated uniform and equal, because that is a very high burden and requires some kind of knowing and intentional act to cheat a taxpayer, basically. And we knew that was a high burden, but we went into this because our valuations were dramatically different than other RECs and were wrong with respect to our RECs.
Let me ask you a question. So your opposing counsel said, in response to Justice Stiegel, about, I guess, what the interest would be is that you could secure lower interest on federal subsidized loans if you kept it in like an equity account. Would that be true?
This goes back to Justice Stiegel's questions about incentives.
Right.
Yes, these are member-owned, member-run cooperatives who have created bylaws under KSA 17-4601 et sec. And those bylaws say we're going to take excess margins and make them patronage capital. We have to refund them, and they choose.
Right. Now, I understand that, but what I'm saying is, if you're getting a loan, is that one of the benefits, the incentives is that you get a lower interest rate because of this patronage account, or that, that it's more stable, or that the money's in
Yes.
there.
It is, as in any business, the more equity you have, the easier it is to go get financing. And that gets back to Justice Stiegel's concern about, there was no evidence about instability of the current
Right,
REC.
But if an entity that is going to loan money makes a decision and says, if that money is in an equity account and can be used to support the cooperative versus that money, and even though it's owned by, it's an equity account owned by the owners, if it's in that, I don't know what I want to say, but in that form versus in the pocket of the individuals that own the cooperative, we're going to give a lower interest rate because the
You're
money's
more
right there.
stable, you are
Right.
more stable and more financially
Right.
secure
Well, should that be taxed?
because it's equity. And a point, Mr. Kahn, the expert that Mr. Smith touts in his brief, admitted that an equity account should not be included in an income approach. So if it's defined as equity and it's used to secure that, it's not, our basic point was, you get $1 of patronage capital, it is not the same as $1 of income. And that's why we never asked for this entire MSA to be ignored. We asked that it be looked at in a different manner with respect to your loan requirements and your ratios, so that you first had to secure the financial stability of your REC. That's all taxable. The margin above that goes into the patronage account would not be subject would not be included.
Is the patronage account interest bearing?
No,
So you don't make any interest on that at all?
no.
It is the basic point that your argument is that money is a capital contribution, not income.
Correct.
Right, okay.
And so
Okay.
I guess there's another way to skin the cat, so to speak, which is a member-owned REC could accept the credit as a pass-through refund on the utility bill and just require an X percentage of capital contribution to come right back.
It could through its board of directors.
And isn't that Doesn't that get you in exactly the same spot?
Well, it would automatically, if it's received as it could, I haven't thought of that. I haven't thought of that before, but so they take the refund, they refund it to the customer.
I mean,
on a
yes,
monthly
this whole
bill.
dispute just strikes me as, I mean, it's important, don't get me wrong, I'm not denigrating the dispute, but it is somewhat semantic. You got dollars that are sitting there, and the only question is it a capital contribution or income? And because of the unique way that the REC takes in and classifies the dollar, there's an ambiguity that has popped up. We can't tell. This is why we're having this whole litigation. You could do it in a much more straightforward fashion.
Well, perhaps it is straightforward now because every bylaw says exactly how those are to be treated.
Okay.
And that would be, I think, my answer, that the bylaws handle that. They're adopted pursuant to Kansas law, and they should control these member-owned utilities. And I thank you very much for your time.
Can I just ask one final question before you go away? And you may have answered this already in response to some other previous questioning, but I just want to understand the testimony of the Barberich expert. During, I think it's in record volume 2, you're talking about the 3 different options for handling the credit. And then you ask about what does that mean in terms of valuation? He says, from a valuation perspective, under fair market value, it should have no effect. It should have equal effect among similarly situated properties. So it does sound to me like the argument on uniformity is sort of subsuming the fair market value argument. It's that they all should be treated, it should have the same effect. There should be uniformity. And the fact that it doesn't means that there's a fair market value problem. Am I misconstruing the context of this testimony?
Trying to remember the context because I saw that quote. If you do this in one of those 3 ways, what I think you say, it shouldn't have the dramatic effect on valuation that it has.
Right. Right. It should be uniform. It should have the same effect on fair market value, regardless of the treatment of the credit.
Yes.
And my problem with this exchange is no one says that the way the department is doing this or the division is doing this violates generally accepted appraisal procedures, which is the statutory standard, right?
That is
No
the
one
statutory
said it.
standard. Nobody said those magic words, Your Honor.
Do they need to?
I think we have gotten away over the centuries from pigeonhole pleading or magic words. And the context of all the record here is that valuation was an issue. It was part of the uniform and equal question because you can't escape it as part of the uniform and equal. But it was part and parcel of the BOTA record and part and parcel of the district court record. And I believe the BOTA record allows us to raise that in the de novo trial. Thank you.
Counsel, I know you have limited time. I'm just going to jump right in. This will be my only question. You heard the exchange. Would you agree that if an REC passed the credit through on the bill to the customer and through their bylaws or the decision of the board of directors added a capital contribution charge, that would not be taxable under the income approach?
Well, it depends. If it's communicated to the customer in the monthly invoice and it's not.
Yeah,
in
it's
this
a
case,
separate line item on the bill. It says capital contribution.
That's not the facts in this case.
I know. I'm just trying to understand
That
the
might be
impacts.
that might be a reasonable consideration. You have to understand, though, that that money is still available to the co-op to be spent for operating expenses, to basically be spent to improve
Right. I'm
distribution.
just trying to understand if the position of the state is that we will not try to tax capital contributions
If it's
under the
ma-
income approach.
If it's made clear in the year of payment.
That's what I mean. Yeah.
And it's made very clear to the customer. See, in this case, it's not made clear to the customer when they pay the invoice, nor at the end of the
Yeah.
year
No,
when they do capital
I appreciate that.
contributions.
I think
They
I
don't make a
understand.
distinction.
Yeah.
But here's the way I've been thinking about it, so correct me. So because the 8 RECs, commissioners here, taxpayers here, because they don't give the customer a break on how much they're charging them for electricity, when that customer pays the bill, that money goes into the cash drawer, or the cigar box, I mean, just the cash drawer. And that's what the income approach looks at. When, maybe you said that, the 8, their bill is bigger, their customer's bill is larger, so more money's going into the cash drawer than when you give the customer the credit and they pay less money because they got the credit on their bill, that cash drawer has less cash in it. And so when you all go look at the cash drawer, there's more money here and there's less money here.
Correct, Justice Biles.
And then you take the expenses. The other question I had was the KEPCO, when they give the credit that starts this thing, or when they give, does that reduce the REC's bill to KEPCO for the electricity? See what I'm saying?
Sure. My understanding with KEPCO, and I've got some issues I want to deal in rebuttal, but my
Well,
issue,
my questions are.
the thing about KEPCO is that that is basically an estimate of, at the high end of what they may charge these recs, right? And that's not in reality what they charge them.
My bottom line is the relationship between KEPCO and the REC does not reduce the expenses of either REC.
Right.
It's just more cash coming in because
More
of the
ca-
way they bill their customers.
Right.
Okay, fine.
I'm saying that the revenue calculation is completely between the consumer, the member, and the local rural electric cooperative. It's not generated by abstractions between the distributor and the rural electric cooperative. And that gets to Justice Standridge's questions. And I'm moving from a PVD to more of a tax person here, but the idea is that we can't advance to go collect $200. This payment of money needs to go through a revenue consideration. It needs to be factored against operating expenses to develop net operating income. And then you get down to EBIT or EBITDA, and then you get down to net earnings. And that's where it becomes margin and profit. And the fact is that we want the court to look at the substance rather than the form and say, this has to be originally treated as income, because that's what it is. It's available for the recs to spend and use. And I'd also, again, I'll just follow up with the issues regarding jurisdiction and whether it was raised before BOTA. You know, the issue here is that this isn't a small dispute regarding the size of a garage in a property valuation residential cases. You have sophisticated parties with very good lawyers that have lots of capital. So when they prepare a pleading, when they make an appeal, they know what they're doing. And in this case, the primary expert presented to you, Mr. Barbrich, issue here is they had a USPAP problem, right? Under the ethics rules of 1.4 USPAP, you can't issue evaluation appraisal if you have a bias or if you have a preordained position on an issue, right? Well, in this case, and I'm not being pejorative to Mr. Barbrich. I mean, he advocated for these same tax representatives. He advocated this issue on their behalf as a tax representative for him in 2017, 2018. So what that means is that the primary witness by the recs had a USPAP conflict of interest. So he had to be very, very careful. And he couldn't tell you that this is a USPAP estimate of value because he wasn't presenting an opinion in that capacity. So he had to limit it into the argument of uniform and equal, which is a broader idea. So this isn't something accidental or we're not reading far enough into the pleadings.
Was that conflict developed in the record?
Yeah, it was developed in cross-examination, direct and exact. It was basically there's a lot of go between the rec direct and the PVD's cross-examination, making it very clear, because Mr. Barbridge kept getting close to that line, saying, hey, this is my opinion of value, this and that. We had to keep bringing him back and saying, no, I can't provide an estimate of value. I'm not a licensed Kansas evaluator. I basically acted in a capacity as a tax representative, sitting in my same shoes in front of BOTA, possibly, definitely in the informal hearings. And so because of those issues, he wasn't really in a position to basically offer an estimate of value. And he didn't go to the trouble of a cost approach or comparable sales, which are other requirements. Now, with regard to Mr. Musil's comments about Mr. Can and his basically acknowledgement that this wasn't a revenue issue, the fact is we're dealing with classical, general accepted appraisal practices here, and even general accepted accounting practices, right? And it's classical to say when a customer pays you revenue to consider that income. That's the normal default standard. And what the Rex asked BOTA and what the Rex asked district court in their quasi-valuation claim is to adopt this novel concept created by a tax representative who now is turned into an expert witness. And we believed in that capacity. I understand one of the only issues in this case where there is no deference given is the credibility of the witnesses, right? I argue that everything else, basically deference, this court can basically consider it unlimited. But as it relates to the credibility of the witnesses, the district court only evaluated that in front of Barbridge, Can, and Knudsen. It didn't comment about credibility in relationship to the USPAT valuation presented by PVD versus Mr. Barbridge's maybe, maybe not valuation opinions. I have nothing further. Is there any questions?
But when that testimony of Barbridge, you know, it comes close to the line, doesn't, you move it back. But when you're arguing that the treatment of the credit should have no impact on valuation, and then there's other evidence indicating that it does in this certain one treatment of the credit, can't we infer from that that's a challenge to the valuation methodology? Or what would be wrong with that?
Well, what would be wrong with that is the fact that when big sophisticated parties like big commercial entities or utilities like this, they want to present an issue of fact for this court in considering valuation. So you have competing USPAT valuations. And there you dig deep in to see, well, who evaluated it correctly according to uniform standards. That's not the context for you here. Right. Thank you.
Thank you to both parties for your arguments this morning. The court will take this matter under advisement.